Welcome to all. Today, as a part of the course on the insolvency and bankruptcy law in India, today we are going to discuss the concept of commencement of CIRP on that moratorium. So before that, let us discuss what we have discussed previously. In the previous lessons, we have discussed who can initiate the CIRP process. So three categories of the persons can initiate the CIRP process. One is financial creditor, operational creditor, and corporate debtor himself. So in the previous classes, we have discussed how to make an application or what are the criteria for making an application by the financial creditor, operational creditor, and corporate debtor. So once the application is admitted by the NCLT, that is adjudicating authority, then immediately moratorium will come into the picture. Now let us discuss what is the objective of moratorium. So Insolvency Law Committee Report 2020, they have given the explanation why and the objectives of the moratorium. The moratorium period is critical for running the corporate debtor as a going concern during the CIRP. So why? Because when CIRP process, that is the insolvency petition, is filed before the adjudicating authority, then NCLT will declare the moratorium. Once the moratorium is declared, then no creditor or any other person can file a case against the company, so that the company can continue without being affected by the legal disputes. So the licenses, permits, quotas, concessions, registrations, or other rights that the corporate debtor enjoys forms the basis for its business, without which it will not be possible to resolve the corporate debtor as a going concern. So please remember, when the moratorium is fixed, the licenses, permits, quotas, concessions, whatever the rights that the corporate debtor is having, all the rights will be in existence. So no right will be suspended. So they can continue as a going concern. So that is the basic objective of the moratorium. So once the moratorium is fixed, once the moratorium is attracted, the licenses, permits, quotas, concessions, registrations, all the rights will be with the corporate debtor only, and it is not going to impact the going concern of the corporate debtor. So there is a basic objective of moratorium. Now if you look at section 13, which provides that declaration of moratorium and public announcement. So according to section 13, subsection 1, the adjudicating authority, after admission of the application under section 7 or 9 or 10, so section 7 is financial creditor, section 9 is operational creditor, section 10 is corporate debtor. So once the application is admitted, okay, the adjudicating authority shall by an order declare a moratorium for the purpose of referred to in section 14. So for the purpose of section 14, the adjudicating authority is going to declare the moratorium. So that is, once the application for initiation of CIRP is admitted by the NCLT, so instant moratorium is imposed on the corporate debtor. So immediately the moratorium is imposed. So it is automatic in nature. Now let us discuss section 14. So section 14 is the fundamental section dealing with the main section dealing with the moratorium. So subject to provisions of subsection 2 and subsection 3, on the insolvency commencement date, the adjudicating authority shall by order declare moratorium for prohibiting all of the following. So once the insolvency petition is accepted, so once the insolvency commencement date is notified, so that is when the application is admitted, that is considered to be insolvency commencement date. Okay, such date is considered to be insolvency commencement date. So on the insolvency commencement date, the adjudicating authority shall by order declare the moratorium. So he is going to declare the moratorium from such date onwards. So what they cannot do? The institution of suits or continuation of pending suits or proceedings against the corporate debtor, including execution of any judgment, decree or order in any court of law, tribunal, arbitration panel or other authority. So clause A provides that you cannot initiate any legal proceedings or you cannot continue the legal proceedings. Okay, so first point, institution of suits. So that means you cannot initiate any legal proceedings. continuation of pending suits. So that means you cannot continue the pending suits also. Okay. So again is the corporate debtor. So maybe it includes judgment, decree, order of the court. Okay. So either it can be decree, order of the court, tribunal, arbitration panel, or any other authority. So you cannot pass any action against the corporate debtor. So that is the crux of this subsection. Then they cannot transferring, encumbering, alienating, or disposing of by the corporate debtor any of its assets or any legal right or beneficial interest therein. So once the moratorium is fixed, okay, once the moratorium is decided, then in such cases corporate debtor cannot transfer or they cannot alienate any property, they cannot dispose of, that is they cannot sell any property. Why? Because once the moratorium is fixed, okay, so CIRP process will be started. Then interim resolution professional will be appointed, subsequently resolution professional will be appointed. Then he is going to maintain all the assets of the company, and in case if the liquidation is ordered, then all these assets will form part of the liquidation estate. Okay, so that's why to decide the actual value of the company, it is necessary to ensure that all the assets, all the property of the company is vested with the company only. So that's why it is prohibited. Okay, so transferring, encumbering, alienating, dispose of, so whereby any kind, okay, so you may be doing in any manner, maybe transferring, encumbering, etc., whereby if the company is parted, that is corporate debtor is parted with the assets of the company, that is prohibited. Okay, so that is the basic objective of this section. Then any action to foreclose, recover, or enforce any security interest created by the corporate debtor in respect of its property, including any action under SARFAESI Act. So the financial creditor, generally any financial institution, whenever they are giving loan to the corporate debtor, they can exercise the right under the SARFAESI Act. So these actions, that is maybe for the action for foreclosure, recover, or enforce any security interest under the SARFAESI Act, is prohibited during the moratorium period. Okay. Then the recovery of any property by the owner, that is clause D. The recovery of any property by an owner or lessor where such property is occupied by or in the possession of corporate debtor. So you cannot recover. Okay, any owner cannot recover the property that is in the possession of the corporate debtor. Whether corporate debtor can recover the property from other person, yes, that is possible. Okay, so moratorium is applicable for the benefit of the company. Okay, next one. So explanation is there under this section. For the purpose of this subsection, it is hereby clarified that notwithstanding anything contained in either law for the time being in enforcement, a license, permit, registration, quota, etc., that is given by the central government or state government or any other sectoral regulator, okay, so under any law for the time being in enforcement, shall not be suspended. So here what they are trying to say is, so whenever you are having any licenses or any kind of registration, okay, so these are all considered to be rights. Okay, so these are all rights of the company. So that's why these licenses, okay, so quotas, concessions will not be terminated because of the moratorium period. Okay, so subsequently we are going to discuss with the help of the judgments. Then the supply of essential goods or services to the corporate debtor as may be specified shall not be terminated or suspended or interrupted during the moratorium period. So this is another important concept. Okay, section 14 subsection 2 provides that whenever you are rendering any essential services, so essential services, there is a definition is there what is included in the essential services. So if you are providing essential services to the corporate debtor, then they are not suspended, please remember. Okay, so for the essential services you can make the payment. Okay, because if you want to maintain the company as a going concern, essential services are required. Okay, so provision of electricity, okay, water supply, basically these are all considered to be essential services or goods. Okay, next one, where an interim resolution professional or resolution professional, as a case may be, considers the supply of goods or services critical to protect and preserve the value of the corporate debtor, so and manage the operations of such corporate debtor as a going concern, then the supply of such goods or services shall not be terminated. So if the resolution professional is of the opinion that to maintain the company as a going concern, the corporate debtor as a going concern, if he is of the opinion that maybe supply of some goods or services is critical and to protect the interest of the company in such cases, so such services or the provision of such services or goods shall not be terminated. To ensure that, okay, this clause is there to ensure that the company is a going concern. Why? Because that is one of the basic objective, main objective of the IBC. Okay, so the company should be maintained as a going concern, and the resolution professional is going to get the maximum out of the available assets. Okay, so that is the basic objective of the legislation. Then the proviso of subsection 1 shall not apply to such transactions or agreement or arrangements or other arrangements as may be notified by the central government. Okay, so the subsection 1, that is moratorium, shall not be applicable to certain transactions which are notified by the central government. Okay, one of such transaction is a surety in a contract of guarantee to a corporate debtor. So if any person is a surety to the corporate debtor, then moratorium will not be applicable. Okay, then under subsection 4, the order of moratorium shall have effect from the date of such order till the completion of CIRP process. So the moratorium will be implemented or it is operative from the date of CIRP till it is completed. Okay, so that is if the adjudicating authority approves the resolution plan under section 31 or order for liquidation of the corporate debtor under section 33. So as already we have discussed, once the CIRP process is started, the resolution professional will ensure that the company is a going concern. Once the company is a going concern and he'll try to manage the company, then subsequently he'll invite the resolution applicants to submit the resolution plans. Okay, then COC will decide whether to approve the resolution plan or not. Once that is decided, then resolution plan will be implemented. That is one option. Second option can be the COC is of the opinion that resolution plan cannot be approved, or else no resolution applicant is willing to purchase the company or willing to provide the resolution plan. In such scenario, NCLT will give the order for liquidation of the company. So once if you start the CIRP process, two outcomes can be there. First outcome can be either you are coming up with the resolution plan and the resolution plan is going to be implemented. Second result can be resolution plan is a failure. Okay, so maybe you are unable to approve the resolution plan, that is COC is not approving the resolution plan, or else you are unable to get the resolution plan. In both the cases, NCLT will give the order for liquidation of the company. Okay, so till that period, that is when the company approves, when the NCLT approves, the adjudicating authority approves the resolution plan, or else when they are giving the order for liquidation, till that time the moratorium will be in enforcement. Okay, so what is the meaning of moratorium? Moratorium is a period wherein no judicial proceedings for recovery, enforcement of security interest, sale or transfer of assets or termination of essential contracts can be instituted or continued against the corporate debtor. So this is the basic meaning of moratorium. So when moratorium is implemented, during that period no judicial proceedings can be enforced. So you cannot file a case, you cannot recover anything from the corporate debtor. So that is the crux of the moratorium. Now let us discuss what is the basic purpose of the moratorium. The Supreme Court in the case of Indian Overseas Bank versus RCM Infrastructure Limited. In this case, the Supreme Court has given the comment. It is thus clear that after the CIRP is initiated, there is moratorium for every action to foreclose, recover or enforce any security interest created by the corporate debtor. So the Supreme Court has pointed out that once the CIRP is initiated, okay, so there is a moratorium is implemented. So once the moratorium is there, you cannot foreclose any contract or you cannot recover anything. You cannot enforce any security against the company which is created by the corporate debtor in respect of the property. Maybe the property is created as a security under the SARFAESI Act. Okay, so once the security is created under the SARFAESI Act, the financial creditor, if it is a financial institution, they can enforce the security interest, but that is not possible. Okay, so it is clear that once the CIRP is commenced, there is complete prohibition for any action to foreclose, recover and enforce any security. So once the CIRP is commenced, that is moratorium is implemented, and please remember, once the CIRP is commenced, moratorium is automatically implemented. Okay, so once it is done, there is a complete prohibition is there on the action to foreclose, recover or enforce any security. Okay, so this is the basic purpose of the moratorium, to ensure that company is a going concern. Okay, so why? Because if there is no moratorium, the resolution professional will have to concentrate more on fighting the cases. Okay, so I mean defending the cases. So this will take a lot of time. Okay, so to avoid these type of circumstances, the law has given the provision where the resolution professional can concentrate on CRP process, and there is a moratorium is there. Then during that period, you can continue the company as a going concern without any disturbances. Okay, so this is the basic purpose of the moratorium. Then, so please remember, a moratorium under section 14 is automatic. Okay, so once a CRP process is started, commenced, so immediately moratorium will be applicable. It applies to what? So under section 14, it applies to assets of the company and litigation. So if any litigations are there against the company, then moratorium will be applicable. Then connected matters of the CD. So anything that is connected with the CD, that is corporate data. So on all these things, moratorium will be applicable. And please remember, moratorium does not impose restriction on the powers of any constitutional court to exercise its powers under the Constitution of India. So it was held in the case of Canara Bank versus Deccan Chronicle Holdings Limited by NCLAT that, so though moratorium is imposed, okay, moratorium came into enforcement, but the rights under other legislations are banned. That is, they are barred. You cannot exercise the rights under other legislations, but constitutional rights cannot be violated. Okay, so you cannot impose any restriction on constitutional rights. Okay, the power of any constitutional court to exercise its powers, so they can always allow the petitions, maybe for the contempt of the court, maybe for exercising your rights. Okay, so you can always approach the court of law. Okay, so your constitutional rights are not barred by the section 14 of the IBC. So automatic stay of proceedings. So now onwards, from now we are going to discuss various decisions. Okay, so how moratorium is going to be implemented. Automatic stay of proceedings. So in the case of Falcon Tides Limited versus Godis Overseas Private Limited, the Madras High Court held that any proceedings to recover the property from the CD is barred. So you cannot file any cases. You cannot initiate any proceedings to recover the property that is there in the hands of the CD. You cannot initiate any proceedings against the CD. Okay, so all these things are barred. So any proceedings initiated prior to the declaration of moratorium. Suppose take the example, moratorium is fixed today. That is, CRP is started today. Possibility is there, before this actually one case is already pending. Okay, one proceedings are already instituted. Okay, so any proceedings instituted prior to the declaration of moratorium cannot continue, even they are all stalled. You cannot continue against the CD. Okay, so you cannot file a case now, you cannot continue the cases also. Okay, so that is the effect of the moratorium. Then arbitration proceedings. So whether arbitration proceedings can continue or not. So Supreme Court in the case of Alchemist Asset Reconstruction Company Limited versus Hotel Godawan Private Limited. So in this case, Supreme Court held that the arbitration proceedings cannot be commenced on the imposition of moratorium. So you cannot continue the arbitration proceedings once the moratorium is imposed. So that means even you cannot continue the arbitration proceedings also. So you cannot continue and you cannot initiate also. Okay. Then NCLAT in the case of Tata Motors Finance versus Jordan International Private Limited. In this case, a financial creditor has sold hypothecated asset post admission of the CD into CRP. So the financial creditor who is having the possession of the property or who is having control over the property, hypothecated property, after admission of the CD into the CRP, he sold the property. Okay, then it was held that such transfer is void. Why? Because you cannot alienate or you cannot transfer any asset of the company. Okay, so that's why once the CRP process is started, moratorium is in enforcement. Okay, so any transfer is void. Then in another case, the NCLAT permitted such creditor. So in the same case, the NCLAT permitted such creditor to deposit the money realized from such sale to the CD. So the financial creditor in the Tata Motors Finance Limited's Tata Motors Finance case, The financial creditor sold the property, hypothecated property. The transfer is void, but already sale is completed. Okay, so that's why the proceeds of the sale must be deposited to the CD. So NCLAT held that it has to be deposited with the CD. Okay, then arbitral tribunal passed an order prior to the admission of the CRP but not executed. So in the case of NCLAT, in the case of Sri Satyanarayana versus Vasudevan, NCLAT held that if an arbitral tribunal passed an order prior to the admission, okay, so prior to the admission of CRP, that is CRP is not yet started, but before that arbitral tribunal has already passed the order, but that is not yet executed. So passing the order is given different, and after passing an award or after giving an award, you have to execute, you have to file a petition for execution. Okay, so award is passed but it is not yet executed. Okay, then what is the scenario? Okay, so how to deal with that? So in the case of Sri Satyanarayana versus Vasudevan, NCLAT held that such award should be treated appropriately under the resolution plan because it is not yet executed. Anywhere once the CRP process started, you cannot execute it immediately. So that's why depending on the resolution plan, in the resolution plan you have to consider the award, then you have to appropriately treat the award accordingly in the resolution plan. Okay, so you cannot immediately execute the arbitral award. Okay, then in another case la, V. Nagarajan resolution professional, that is resolution professional versus Meenakshi Energy Limited. So in this case la, NCLAT, National Company Law Tribunal, held that arbitral tribunal passed an order for production of the document. So the arbitration proceedings are going on. So in the process, arbitral tribunal, they passed an order to submit the documents for considering the evidences. They have given the order for production of the document. So is it valid? Whether arbitral tribunal can pass an award or can give the order to submit the document or not. So it was held that it is a valid one because they are not determining the rates. Okay, they are not affecting anything. So here the arbitral tribunal is only asking the production of documents. So that's why it was held that by the NCLAT that it is valid one. Okay. Then moratorium does not extend to subsidiary company. So another question mark is that if CRP process is initiated against the holding company, whether the moratorium, so because once the CRP process started against the holding company, automatically moratorium will be implemented and moratorium is affected to the parent company. Now the question mark is that whether is it applicable, is it extended to the subsidiary company or not. So in one of the case law, that is Axis Bank Limited versus Alok Infrastructure Limited, NCLAT held that initiation of CRP against the holding company do not prevent initiation of CRP proceedings against the subsidiary company. So because both the companies are separate and because both the companies are separate legal entities, so if you are initiating CRP process against the holding company, you can also initiate the CRP process against the subsidiary company because both the companies are different. Okay, so it is not preventing the initiation of CRP proceedings against the subsidiary company. Okay, so that is different and this is different. And CRP process can be initiated and continued parallelly against both holding company and subsidiary company. In another case law, the Telangana High Court held that is Hindu Eastern Province Projects Private Limited versus Telangana Housing Board. In this case law, Telangana High Court held that there is a possibility CRP process can be initiated against both holding company and subsidiary company parallelly. So both are different cases. Okay, parallelly you can continue the cases against both the companies. Even that is also possible. Okay. Now, all the creditors are prevented from appropriating any monies from the CD. So once the moratorium is enforced, that is moratorium is applicable. So all the creditors are prevented from appropriating any monies from the creditors. So corporate debtor. So that is, suppose take the example, one of the person is liable to make some payment. That is, he is also entitled to receive the money. He is a creditor as well as he is a debtor. So can you appropriate the payment? Can you set off? Okay, or else can you use the money that is there with the financial creditor that belongs to the money belongs to the corporate debtor? Can you appropriate it? No. Okay, so you are not supposed to appropriate any money that belongs to the corporate debtor. Okay, so in the case of Indian Overseas Bank versus Dinakar T. Venkatrama Subramanian, professional for Amtech Auto Limited. In this case, NCLAT held that once the moratorium has been declared, it is not open to any person, including the financial creditor and the bank, to recover any money from the account of the CD. So even the bank also cannot deduct any money. They cannot appropriate any money from the corporate debtor. Okay, so all transactions are prohibited. So in another case, Vijay Kumar V. Iyer versus Bharati Airtel Limited, NCLAT held that amount due to the operational creditor prior to the date of CRP cannot be appropriated during the moratorium period. So before CRP process started, okay, if any amount is due to the operational creditor, okay, so such amount cannot be appropriated during the moratorium period. So that means you cannot impose any liability, you cannot adjust the liability also, even that is also not possible. Okay, so if money is deposited into the court, okay, maybe there is a possibility the court of law can give the order that you have to deposit the money with the bank, with the court. Okay, then in such cases such order can be enforced. Okay, so if any money is deposited into the court on account of any order of the court, such amount does not constitute an asset of the company, because the amount is there with the court. Okay, so once the court gives the order that you have to deposit so and so money, then until unless the exact rights are decided by the court of law, the money does not belongs to the company. So that's why in the case of Reliance Communication Limited versus Rajendra P. Bansal, the Mumbai High Court held that once the money is deposited into the court on account of any order given by the Honorable Court, then the money that is there with the court does not belongs to the company. Okay, it does not constitute it does not form part of the asset of the company. Okay, then moratorium does not prevent proceedings which are for the benefit of CD. So it is interestingly we have to understand that moratorium does not prevent. So all the proceedings are barred. You cannot initiate any proceedings against the company. Suppose if any transaction, if any proceedings are beneficial to the CD, that is corporate debtor, will it be allowed? Okay, the Delhi High Court in the case of Power Grid Corporation of India Limited versus Jyoti Structures Limited. Okay, so in a petition under section 34 of the Arbitration Conciliation Act, where the proceedings are for the benefit of CD and no liability on the CD, then such proceedings can continue. So in this case, Delhi High Court held that when you are filing a petition under section 34 of the Arbitration Conciliation Act, where you are trying to enforce your rights, okay, so where the proceedings are for the benefit of the CD, so the CD is going to receive some money, okay, and you are not going to impose any liability because of such proceedings. Okay, in such cases, if any proceedings are beneficial to the CD, then you can continue such proceedings. Okay, then in another case, Ram Ratan Kanungo RP of D Thakur Construction Private Limited versus VAPCOS Limited. So in this case, NCLT held that it ordered refunds and repayments to the CD. So if CD is entitled to receive any money or CD is entitled to receive any refund, then in such cases CD can recover the money. So in a simple language, I can say if you are receiving any money to the CD, then that is allowed. If you are making the CD liable, okay, so always liability, whenever you are imposing the liability on the CD, that is prohibited. Okay, then in another case, SSMP Industries Limited versus Parkan Food Processors Private Limited. So in this case, the Delhi High Court permitted counterclaim proceedings to continue against the CD, but award or decree in such counterclaim cannot be executed. Okay, so in this case, some case is pending actually, and the opposite person were claiming some counterclaims. Okay, so no, when CD is claiming some amount, maybe imagine 100 rupees, opposite party is claiming that yes, we are liable to pay 100 rupees, but we are also entitled to receive 50 rupees. Okay, that is counterclaim they are doing. Then will it be allowed or not? Yes, counterclaim can be allowed. Why? Because even though they are allowed to claim the counterclaim, until the amount total process is completed, okay, so you cannot set off the amount. So that's why award or decree in such counterclaim cannot be executed. So though the order is given, you cannot execute it immediately because moratorium period is there, but counterclaim can be submitted, so that okay, when the resolution professional is assessing the assets or assessing the turnover of the turnover of the corporate debtor, he can clearly understand what is the asset of the company. Okay, so because counterclaim becomes the liability to the corporate debtor, so that's why he can assess the exact real picture of the company. So that is why they allowed counterclaims, but award and decree in such counterclaim cannot be executed. You cannot execute the award or decree. So there is a logic behind it. So in the present class, we have discussed about the objectives of moratorium. What is the objective behind the moratorium? We have discussed. Then in this class, we have discussed section 13 and section 14, where under section 14, the court is having power to impose a moratorium. So once the application is admitted, that is CRP application is admitted by the adjudicating authority, immediately adjudicating authority will give the order for moratorium. Then we have discussed the purpose of moratorium. Then we learned that once the moratorium is announced, then immediately all the cases against the company will be stayed, automatic stay of proceedings. So that means no one can file a case against the corporate debtor, and all the cases which were pending before any other court of law will be stayed. Then we have discussed the concept of whether the moratorium does it extends to subsidiary company. So we learned that the moratorium does not extend to the subsidiary company. Then whether moratorium prevent the proceedings which are for the benefit of the corporate debtor, we have discussed. So we learned that if any proceedings are for the benefit of the corporate debtor, such proceedings need not be stopped. So it does not prevent the proceedings which are for the benefit of the corporate debtor. We have discussed. Thank you.